Thank you.
Yes, sir.
Honorable Richard Raymond and committee members, my name is Dr. Robert Anderton. I'm a practicing dentist and an attorney. I'm a former president of the Dallas County Dental Society, the Texas Dental Association, and the American Dental Association. As an attorney, I represent a large number of orthodontists, pediatric dentists, and general dentists who are involved in the current Medicaid pre-authorization dispute and the many controversies regarding allegations of Medicaid fraud and payment hold. Excuse me. My purpose here today is to urge this committee to support the passage of Senate Bill 1803. This bill would apply current law found in the federal statutes to provide relief to doctors who are being forced out of business because of the oppressive results of a payment hold. It would also require a fair hearing on any payment hold to be scheduled within a reasonable period of time. Mr. Belanga laid out very well what's happening today. Many of these doctors are looking, as you heard him say, with the possibility of looking at the loss and having to come up with millions of dollars. And I think more importantly, as he pointed out, it's not the money as much as we're talking about due process. The doctors are being forced into bankruptcy and out of business before they're even given a hearing, and they're treated as if they were guilty before they ever get a chance. So this Senate bill will correct a lot of those problems. If allowed to go into effect, the provisions of this bill will allow the respondent providers a fair hearing in the State Office of Administrative Hearings. It will also provide an avenue of appeal directly to State District Court, as Mr. Belanga said, which will allow a fair venue to consider a proposal for decision from the SOA judge. If passed, the bill will go into effect in September of this year and will apply to all cases after the effective date. And providers whose cases are currently under investigation and are on payment hold, however, need help immediately in order to continue to serve the many Medicaid beneficiaries who desperately require their services. The federal regulations mandate that the state Medicaid agency, as we've heard, must suspend all Medicaid payments to a provider after the agency determines there is a credible allegation of fraud. Currently, based on this provision, after the Texas OIG conducts an investigation and alleges fraud without a hearing, a payment hold of 100% of the provider's funds is put in place with notice after the fact. The 100% hold then remains in place virtually indefinitely unless the OIG determines that the amount of the hold can be reduced or the provider can prevail at a hearing on the merits of the case. If allowed to remain in place for any length of time, a 100% payment hold is fatal to a dental practice of most providers. Most dentists, we don't realize, are not that big businesses, particularly some of these Medicaid providers. You can imagine 100% hold to some of these people who are providing 90 to 90% of Medicaid puts them totally out of business. Even if reduced to 50%, with the practice overheads at or near 70% or more, practice simply can't survive. The practices, as do now, have been forced totally out of business, and others have been forced into bankruptcy now. Such results at best have a detrimental effect on the dental Medicaid program in Texas, leaving children who desperately need care at a tremendous disadvantage. We have had to take children out of some of these practices the practices that have had to declare bankruptcy and gone out of business. We have literally had to find patients, other offices to go into, and some of these are in remote areas. So it's been very difficult to find doctors who are still in business who can continue to treat these patients. So a lot of them are having to go long distances to get that care. But according to the federal regs, if the state determines that payment suspension in whole or in part is not in the best interest of the Medicaid program, or if a suspension will have an adverse effect on the beneficiary's access to care, the payment hold can be modified or terminated. But it rarely is. This provision in the federal statute, even though it's there, is not being applied. Most of these holds, when they are put into effect, remain at 100%. And so a few of them have been reduced down to some to 50%, some even down to 25%. But even at that, if allowed to remain in effect, for any period of time, these practices simply can't survive. So I urge this committee and the executive commissioner to apply this provision immediately and at least make reference to it in the final bill. Under the current HHSC rules, a provider who is placed on a payment hold may waive the informal review process and request an expedited hearing at the State Office of Administrative Hearings. However, this process can often take several months or longer, and again, this length of time on a 100% payment hold is fatal to the dental practice of most providers. This detrimental effect in the current rules will be cured with the passage of Senate Bill 1803. But now we've got some of these cases that have been put back for months and months and months, and some are going into over a year now just to get to a hearing. But there's other vital interests at stake here too, and this is the Medicaid beneficiaries. My firm represents dentists with well over 100 dental offices, orthodontic, general dentistry, and pediatric dentistry all across the state. These offices are under investigation or have been placed on a payment hold. They currently have in treatment well over 100,000 Medicaid children, all of whom will benefit by passage of this bill. In conclusion, the doctors, whether they are under investigation or on payment hold, along with the children they treat, all entered in the program as providers and beneficiaries in good faith. And ladies and gentlemen of the committee, I think, keep in mind, there's not $1 of these orthodontic and dental services were paid for without prior approval. They were all approved. Currently, doctors are being forced out of business due to the length of time necessary to resolve the allegations against them. Beneficiaries are forced out of treatment or into doctors' offices they did not choose. The time frames and appeal process provided in this bill will speed up the process and bring a quicker resolution. Now, recognizing there are no quick answers, I urge you to consider some possible additional actions. The doctors who have been approved as providers in the program, even though they're under investigation or have a disciplinary history with the Texas State Board of Dental Examiners, should not be excluded merely on these bases, but should be allowed to continue as providers in the program. The TMHP and MCOs are not consistent in the approval process. One entity may approve the doctor while one or more will not approve. Many of these doctors are major providers in highly underserved areas, and in many instances they are one of few, if not the only provider, leaving beneficiaries with no access to care. And two, representatives from the private dental practice community and the dental service organizations should be included as stakeholders in future negotiations regarding program rule and policy changes. Input from those who actually treat Medicaid patients is invaluable in formulating policy and program rules. Inclusion of these providers will help to ensure the viability and effectiveness of the programs and access to care for the beneficiaries. Thank you for your time and attention to these critical issues. I know that this committee, HHSC, OIG, TMHP, and all the MCOs and the provider dentists all have a vested interest in the successful outcome of these programs, especially an interest in providing the much-needed care for the children of this state. That should be and is our only goal. Thank you. I'll be happy to answer any questions.
Thank you, Doctor. Members, any questions? Thanks.
Thank you.